Good day and welcome to this week's episode of Strictly Legal on WESN Content Capital. I am your host, Rondell, Donawa, attorney at law. Once again, I'm happy to be alive. I'm happy to bring the law and you. And this week's episode, we are going to speak about the recent matter that surrounds the Court of Appeal decision with respect to the granting of bail to persons committing, accused of committing murder. Of course, this has caused a lot of public debate as to why that persons who have been accused or have been arrested or charged of murder are now being granted bail, particularly in a society that is riddled with crime. Of course, there is a constitution, there are rights associated with this constitution of the Republic of Trinidad and Tobago, and of course this program is to really dissect and give a layman explanation as to how did we arrive at this position with respect to bailable offences, now murder. Of course, I am grateful to have once again my guest, Ms. Renuka Rambhajan, attorney at law, who has over 15 years experience as an attorney. She has practiced both at the prosecution side of things, and now she's a defense attorney, so she has knowledge of both areas of the law. And I believe that she is the most appropriate person to speak on this topic on WESN Content Capital. So without further ado, let me welcome Renuka Rambhajan to our set once again. Good morning, Renuka.
Good morning. Thank you so much, Rondell, for having me.
And how are you?
I am doing okay, a little bit under the pressure, because there's so much work to be done, but I'm doing well. Thank you.
Yes, that's good. And I must congratulate you and your team for taking the bold step with this application. And just to give the public an overview of why are we here in terms of the Court of Appeal now stating that the decision or the previous decision to deny bail for persons accused of committing murder has been unconstitutional. Yes. How did we arrive at this position?
Well, you see, firstly, the name of the case is Achille Charles.
Yes. So
you need to know the facts of Achille Charles. Achille Charles was charged for murder in 2010. He was brought before the magistrate in the Port of Spain jurisdiction for a PI to start. A PI is a preliminary inquiry where the magistrate determines if there is enough evidence for a matter to go before a judge and jury. Mr. Charles had his matter before the magistrate's court from 2012 to 2017. His preliminary inquiry was ongoing. In 2017, the sitting magistrate at the time, the chief magistrate, Magistrate I.S. Caesar, elevated. And as a consequence, his preliminary inquiry stagnated. Subsequent to that, a decision was made for his PI to restart. So then what happened is after he had been waiting from 2012 to 2017 to find out if his matter is going before a judge and jury, the entire matter had to restart again. He challenged the decision, and the judge who dealt with that application said while she sympathized, they had no choice but to restart his matter.
Why did they have to restart the matter? Because that is what I didn't get.
Because the magistrate at the time did not complete the PI. And having left the role of magistrate, she was now functus and therefore could not complete his PI. You would remember that there was much uproar about that, and as a consequence, several of the PIs had to restart. Achille Charles's was one of them. So his PI restarted, and in 2019, on a no-case submission, he was released. He was free to go. So Mr. Charles had spent 9 years in custody for an opportunity to prove his innocence. And at the PI stage, the learned magistrate was of the opinion there was not enough evidence for him to go before a judge and jury. As a consequence, he would have spent 9 years on remand in prison without access to bail. Senior counsel, Mr. Rambhajan, felt that that was a constitutional issue, and he decided to challenge the granting of bail or the denial of bail to persons charged with murder. Now, what you have to understand, the jurisprudential history of the matter.
Yes.
Achille Charles is not the first case where we've challenged the Bail Act. Daniel St. Omer is another decision where I was junior counsel with Mr. Rambhajan. And in that matter, a police officer had been charged and denied bail as well. And the very same type of learning that we see in Daniel St. Omer, the Court of Appeal would have rested its head essentially in the same area on the doctrine of separation of powers and so on. Yes. Very technical way of explaining something simple, which is under the Constitution, you have the right to due process, you have the right to protection of the law. you also have the expectation that the judiciary and the executive will remain separate and apart. So if the judiciary, the judges and the masters and the magistrates are to make decisions, they must do so free of the encumbrance of executive power. That is called the separation of powers.
And of course, we know there's an argument which states that each arm is correlated, and therefore the executive or the parliament correlates to the judiciary because the parliament makes laws.
Correct. So that each of them, and again, I guess because we're explaining things so that the layman will understand, the executive is the government who makes policy, the legislature is the parliament who passes the law, and the judiciary is the arm of the state that enforces the law. So while each relate to each other, they have separate and distinct functions. And what the Court of Appeal said is you cannot pass a law telling a judge you cannot grant bail for murder because that is unconstitutional. And that is what the Court of Appeal decided in Akili Charles.
Now, you mentioned that there was a previous case in St. Omar, I believe.
Daniel St. Omar.
Now, what was the Court of Appeal's decision then? Because they would have, is it that they would have upheld the decision of the lower court?
It was not a Court of Appeal decision. That case was a little bit different. Again, it was a bail case where, I don't know if you recall, there was an amendment to the Bail Act that said persons who committed an offense with a firearm would be denied bail for 120 days in first instance.
And we discussed that actually in our first episode, yes.
So what happened as a result is in Daniel St. Omar, 2 police officers were charged with misbehavior in public office. They had their sidearm, police issued firearm on them when they allegedly took the bribe. So because they were armed at the time of the commission of the offense, 2 police officers were denied bail as a consequence of the 120 days limit. And they challenged that. And even though they were released subsequent to that, and the judgment was academic because the 120 days had lapsed, the argument was still, does the government, the executive, and the legislature have the right to tell a judge, no bail for this, no bail for that? And so that argument translated from St. Omar straight up to Akili Charles. Different circumstance, but essentially the same pillars of law. Protection of the law and the right to not be arbitrarily detained without due process.
Right, so can there be an argument which states that, okay, in terms of the separation of powers, that at least in our jurisdiction versus the United States jurisdiction, that the legislator cannot create law or cannot make law? So therefore, one argument can be, well, the judiciary is trying to now rewrite the law.
Not at all. That can't be an argument. First of all, when you look at the U.S. system and Congress and so on, they do not follow the Westminster system. We do.
Indeed.
The Westminster system follows upon the English law. So if we are to look for comparators, a very close comparator would be Jamaica. Jamaica has almost exact and similar clauses in their bail act as ours, but they allow for bail for persons charged with murder. So in the Caribbean, you will see that we might be one of the few nations that has this idea that murder is non-bailable. There is nothing in the law that says murder is non-bailable but for the first schedule, which the court has now struck down and said is unconstitutional.
Now, let's say, for instance, now we have this issue now where, yes, it's unconstitutional. Now, with respect to persons now who are eligible to apply for bail, I mean, there are a lot of persons right now in remand.
Yes.
I think it's over 1,000 persons.
Yes.
Now, how does that affect the criminal justice system at this point in time?
Well, I can only speak from the perspective of the bar.
Yes.
As a defense attorney, I will say that, of course, when the decision came out, nobody understood that the stay meant we have to wait until the 3rd of March. So I was inundated with calls from persons. I'd like to make a bail application. Well, I want you to make a bail application for my brother and so on and so on.
Okay. I thought you were going to say from inside prison. But
No, not at all, not at all. I don't encourage that at all. So what happened is you had a lot of people reaching out because they did not understand the ramifications of the decision. And really, I thank you for the opportunity for me to explain to the layman what it means. And if you would permit me.
Yeah, sure.
Essentially, bail is to be granted to any person who is charged with an offense. So the first pillar is bail is not punitive. It is not a punishment. i.e., a person who is charged is considered innocent in the eyes of the law. He's innocent until proven guilty. The state laying a charge against you has the burden of proving your guilt. All right? One of the issues the court will have is, having been charged, will you present yourself to hear the evidence against you? So bail is really to ensure your presence at the hearing. There was a decision out of the Privy Council called Hernam and the DPP out of Mauritius. And a simple line from that case is a line every defense attorney uses, which is, bail is to ensure a person's attendance. It's not punitive, it's not punishable. It is an opportunity to go before the court and say, listen, I have been charged. I would like to clear my name, give me an opportunity to do so. I do not have to remain in prison to prove my innocence. So when it is a person is charged, they make an application for bail. The court has specific factors they have to consider when granting bail. And those factors are in the Bail Act. The seriousness of the offense, whether you have good character, in other words, do you have any previous convictions? What are your antecedents, character and social ties? What are your ties to the area? Do you pose a threat to witnesses? And having considered all of these factors under the Bail Act, the court will then determine whether or not you are entitled to bail. So everybody charged with murder can make an application.
But it's not a matter of, because persons were like, does it mean that everyone will get a bail? Bail is not an automatic right.
No, so that's what I'm saying. You make the application and then the judge, the magistrate, whoever you make the application before, they are guided by the sections of the Bail Act as to whether or not they want to grant bail.
And let's go back to the constitutional framework of this entire thing. Particularly, a lot of legislation, it usually states in some, I think it's clause probably 3 or so, whereas this bill is inconsistent with section 4 and 5 of the Constitution.
Yes.
Other persons are always perplexed as to why would Parliament pass legislation that is inconsistent with your rights.
So there is a process.
And what exceptions are there?
All right. So there's a process in the parliamentary process, essentially, when you go before the upper and the lower house to debate a bill. So a bill being debated would tell you, okay, do I need a special majority or a simple majority? Usually, legislation would require a simple majority, which is a normal vote. Yeah. But if legislation is being drafted with the anticipation that it may infringe sections 4 and 5 of the Constitution, a special majority is required, which means you have to have more votes. So there's more pressure on the legislature when you are passing legislation that may appear contrary to the Constitution to have that special majority vote.
Right. So therefore, it still means that if it's challenged, a court can strike out the particular clause.
Yes.
So does that mean that this is going to open the floodgates for many other areas of legislation that infringes on section 4 and 5 of the Constitution?
I think that it is a good move for the jurisprudence that we challenge things that we have accepted as norm. Something that's very interesting, when you look at the first instance judgment in Akili Charles, that is Madam Justice Charles's decision, one of the things she said is, while I do not see it in the law, I'm paraphrasing of course, there is a practice to deny bail for persons charged with murder. A practice does not equate to a lawful right. So that means that a person, and I want to use an analogy so that the layman...
The practice could be custom.
Correct.
Common law.
Correct.
Yes.
So I want to use an example so that the layman could understand how serious this thing is. If 3 fellas go to put on a robbery, and one of them is a taxi driver who they just say, boy, come carry for a drive. He is not aware of what is happening, and a murder takes place during the robbery. The driver of the taxi will be charged for murder. Yeah. And he will be denied bail, as was Akili Charles. And for 9 years, he will have to wait for an opportunity to explain he was just the taxi driver. That cannot be fair. The other 2 who may have had the firearm, who planned the robbery, who may be of bad character, who have a long rap sheet, as they would say, they would not be granted bail. But perhaps the taxi driver, who is of good character, who has good, strong family ties, who's a church-going man, who puts evidence before the court that says, I've never been in trouble before, the court may want to exercise their discretion to grant him bail.
Now, the country, especially our society, has been so incensed by crime.
Yes.
Right, that there are many persons who are uninformed, obviously, because they don't understand legalese or even understanding why it is that someone who supposedly commits an offense of murder should be granted bail. And therefore, they are saying that, well, if you grant bail, then they can go out and commit further crime.
Well, you have to remember this. A person charged is innocent until proven guilty. Mm-hmm. So if I leave the studio now and something happens outside and the police make a determination that I'm culpable, I might find myself before the court and denied bail. It could be that I'm raising self-defense. I will not have an opportunity to raise that until whenever the court decides to treat with my matter, and during that time I'm on remand. Keeping a person on remand does not automatically mean when they come out there that they're not going to commit offenses or commit offenses. In fact, the Bail Act, Section 5.2, deals with repeat offenders. It says if a person has committed more than 3 offenses within a 10-year period, they are to be denied bail. But people are not talking about that.
They don't know that, right?
Exactly. Yes. So what is happening is you have a lot of misapprehension about everybody's like, oh, they're going to let out the killers and crime going to run rampant. That's not going to happen. There is no floodgate that is going to open. There is a process, a judicial process that exists prior to Achille Charles, where anybody can go before the court and make a bail application. All this decision does is it says persons who are charged with bail has the right to make the same application. Yeah. That's it.
And therefore, again, it is up to the courts to decide whether or not this, you can be granted bail.
So a person who has been charged for murder, who has committed offenses in the past, especially if they are violent offenses, somebody who has had charge for possession of ammunition or firearm, domestic violence perhaps, and now they're charged for murder. The court seeing his criminal record is going to say you are a threat to society. So they will not grant bail. You understand?
Yes.
So it's really up to the judicial officer, guided by the factors stated in the Bail Act, to make a determination as to whether or not to grant bail.
Now let's deal with the fact that the AG at the time, I think it was just after the decision, that they wanted a stay.
Yes.
Right? Meaning that they wanted to bar judges from considering bail for persons charged with murder until there's an appeal to the Privy Council.
Yes.
Tell me why that was denied.
Well, not to try to explain the Chief Justice's decision,
yes,
but essentially what the court felt, in my respectful view, is that when you look at the numbers of persons who are in custody, when you look at the existing bail apparatus that is available, as well as you have confidence in your judicial officers that they will be able to manage the system, persons will be able to make their application and have it processed in a timely fashion. What the state wanted to do is to say, listen, while the Court of Appeal has said that this is wrong, let's hold our hand until the Privy Council provides guidance. The difficulty with that is essentially you're asking the court, let us continue to infringe people's rights until somebody else tells us if we're right or wrong. You have to look at the thread of the argument. The argument from Justice Charles was, it's a practice. Court of Appeal comes and says, it's a practice not supported by law and must be struck down. So the persons who are inside, like Achille Charles would have been, had he not been released at no case submission, they are waiting for their opportunity to be heard, whether it is a bail application or even to have their matter start. So you can't tell them, for convenience, while you are on remand, give us 6 months so we could appeal the matter to the Privy Council.
Because it's not a stay, it's not a decision based on damages or anything like that.
Correct. So you can't, in my respectful view, you can't ask the court to stay something when the court says what is happening is incorrect. The duty of the state to protect all of our rights is to ensure that if something is struck down, you immediately begin to effect change. You don't ask for an opportunity to break the change into little pieces. That's
Indeed.
not palatable to somebody on remand.
I like that one, break the change into little pieces. Yes, we are the change, be the change.
Exactly.
Renuka, let's take a pen. We have to take a break. You're
Sure.
watching Strictly Legal on WESN, Content Capital. We'll be right back.
Catch the playoffs and the finals of the Dream 11 cricket tournament on Friday from 11 a.m. only on WESN Content Capital, your home for cricket. Join me, Sule A. Joseph, as I delve into the day-to-day psychological issues plaguing our society. We will discuss behaviors that encompass the biological influences, social pressures, and environmental factors that affect how you think, act, and feel. Site, Thursdays at 11:30 a.m. only on WESN, Content Capital.
I'm talking to Dr. Michelle Khan. She's a health and wellness coach. What your practice entails, what it means to be a health coach, what kind of patients do you see, and what does this practice involve?
Healthcare to me is very holistic. it definitely takes place in the doctor's office, but how you maintain that is what you do at home. What is the energy within your body? What are your beliefs about your health and wellness?
With me now, I have Karen Forbes, another member of the senior women's national football team.
What's up, Doc? Tuesdays and Thursdays here on WESN, Content Capital.
Catch the playoffs and the finals of the Dream 11 cricket tournament on Friday from 11 a.m. only on WESN Content Capital, your home for cricket.
And we're back on Strictly Legal with Miss Renuka Rambhajan, speaking about understanding the consequences of the decision, the recent Court of Appeal decision with respect to allowing persons committing murder offences to be granted, not automatically granted, but being able to apply for bail. Renuka, I know before the break we were speaking about not being the change. And I want to get, I don't want to get too much involved in the politics, but as a society, we're very reactive, always, right? And of course, this can be a wake-up call in terms of how the judiciary or how the justice system rather manages their caseloads. Because at the end of the day, it's a bit unfair for persons, besides whether it be murder, the persons who are on remand for committing offenses are in prison for years without being heard.
Correct. I have many horror stories for you. If you take the murder out of the situation, there was a gentleman who was charged because a gun was found on his property. And again, the police, I was treated with the matter, the police's position was he can't get bail for 120 days. I went before the magistrate and I got bail for the gentleman. The matter, that was in 2020. The matter is still pending. The exhibit is still at the Forensic Science Center. So if we were to follow what the police's position was in this matter, and we did not have laws to protect that man, he would have been in custody, in prison, on remand, waiting to deal with a possession of firearm matter for in excess of 2 years, without bail, while he awaits a report from the Forensic Science Center, which is going to take we don't know how long. That cannot be fair.
Yeah. And of course, justice, as a maxim, justice delayed
is justice denied.
And let's deal now with the, I know in the public domain, just yesterday, there's news circulating with respect to bail that was deemed that was nullified,
yes.
That was granted to Raja Ali and 8 others.
Yes.
Of course, there's a lot of misconception that, the court reversed. Why the court reversed? That means, therefore, it's not working. Can you just quickly explain this particular situation?
I don't want to speak too much about it because I'm not in the matter, so my information is based on what I would have read in the newspaper. From what I understand, Raja Ali and they appeared on the gang-related offenses. It was not the murder of Miss Hal, all right? They appeared before the court in relation to gang offenses. Which
is totally different.
Totally different, yes. And as a consequence, they made an application for bail, which was initially granted by the sitting magistrate at the time. There appeared to be some sort of issue with the granting of bail because they are actually committed to stand trial for murder of Miss Hal. So even though they might get bail on paper, they can't access that bail until they make an application for bail for the murder charge, essentially. So today what I read in the newspaper is that because they were brought to the court by an erroneous method, that is a court note versus a summons, the bail could not have been granted and therefore it was reversed. So it appears to be an administrative error, but it redounded to the benefit of the accused because it means that he had an opportunity to make a bail application. So I want to make it clear. The application for bail, as far as I understand and reported in the newspaper, was in relation to the gang offenses, not the murder.
And therefore, it's the court's, of course, the court at first opportunity has to correct.
Correct. And one thing I want to indicate, the state was unrepresented in the bail application. So the state did not have an opportunity to object to bail. So the magistrate, treating with what was in front of her, exercised her discretion in accordance with the Bail Act. So the judicial process worked. There just seemed to be some sort of administrative error. Because of who he is and the notoriety,
yes.
Of course, again, you said Trinidad is a reactive place. So people, he get bail. And that's not what happened. So sometimes we need to really look at what is happening before we comment.
Yeah. Now, of course, just going back to the particular section that was unconstitutional, which is section 5(1).
Yes.
That cites the first schedule of the Bail Act, but it also says that persons in that first schedule, exceptions to persons entitled to bail includes murder, treason, piracy, or hijacking, or any offense of which death is a penalty fixed by law. So therefore, does that this decision applies to the other type of offenses such as treason, piracy, etc.?
It would. If you strike down one section and a schedule, everything that goes with it is struck down as well.
And in your knowledge, are there any person right now in prison for treason?
No. I think it is only the July 1990 insurrection that would have given rise to any conversation about treason. Hijacking, thankfully, we hadn't had that in Trinidad yet. Piracy, I don't think we've had that yet, but we don't want to give people ideas. We are an island.
And we see what is happening in the world.
Exactly
at this point in time. Now, where does this leave us in terms of, the state intends to challenge these proceedings to the Judicial Committee of the Privy Council? It's going to be very interesting because the Judicial Committee has already adjudicated on the fact that, I know this is a different topic with respect to the death penalty being unconstitutional.
Correct.
So it will be interesting in terms of the type of appeal. What is where is the state going with this appeal?
Well, I think the state is going to ask the Privy Council to reverse the decision of the Court of Appeal. They may cite a number of reasons, one of which might be the existing system and the fact that the law clearly states once you are charged with an offense for which death is the sentence, you would not be denied bail. You would be denied bail based on the first schedule. I think the Privy Council will have to look at the penalty, the way the legislation is phrased, and determine whether or not the state is right in their interpretation or whether we were right. And I want to say this, we were not right singularly. The Law Association joined the matter and supported the argument. So it is not, while some people will want to say it is a political football, it is not a political football because people are not understanding that this was a matter that invited the views of the Law Association, and the Law Association agreed with the arguments that we put forward.
Yeah, and of course, persons they blame lawyers for a lot of things, at the end of the day, you have to have, it's your right to a fair trial, it's your right to be represented.
Exactly.
Right? And attorneys have a right or duty.
Correct.
Right, to represent such accused, right?
Yes, remember when we get called to the bar, we stand and we take an oath. And the Constitution is there for a reason. I want to segue a little bit so that the layman will understand. When we had these lockdowns initially, back in March of 2020, when there was the declaration and they said persons had to stay at home, and you had police officers who were standing on the highway with roadblocks and asking you to see your grocery list when you said you were going to the supermarket. And they said, no, turn around and go back home. That was a breach of their authority.
Yes.
It was an abuse of their power. So you need lawyers, you need the Constitution, and you need brave people who are willing to come forward and say, listen, while this might be an accepted practice, is it lawful? Do we just do it because father and mother used to do it?
Yeah, and that is the issue with our society.
So had we not challenged that, we might still be in a position in a lockdown where the police is telling you turn around and go home. Without a state of emergency, they did not have the authority to do that. So lawyers are required, I think, as counsel. When you say you are of counsel, there is a responsibility that carries. You are required in law, in your own moral standing and ethical purpose, to do what is right and protect the rights of your common, your fellow man.
Indeed. Renuka, I want to thank you so much. I know we are out of time. Of course, I'm sure this is a topic that has to continue. I'm looking forward to the Privy Council arguments and decision whenever the time comes.
Thank you so much for having me.
So thank you so much, Renuka, and all the best to you.
Thank you.
Right, so you have been watching Strictly Legal. It's a wrap on WESN Content Capital. Before we go, I just want to put on my Calypso and hat a little bit as Assistant Public Relations Officer of TUCO, just to congratulate a number of our members members who would have received national awards, such as the Lamo, Luther, Johnny King, Super Blue, Crazy, Not Contender, Mudada, and a few others. Congratulations, we are proud of you, and continue flying the cultural fraternity or the cultural flag high. So again, see you next week for another episode, an interesting episode of Strictly Legal. Have a good day. Goodbye.